Physio at Work podcast. In this podcast, we shed light on occupational health physiotherapy and the important work physiotherapists undertake in private and public organisations, in education and in society, and in shaping the health of Britain. So this is a limited series of 10 to 12 episodes, during which time we'll get to talk to experts in their field of work. And today's guest is Diana Kloss, MBE, who is a barrister specialising in occupational health law. I think I will let you tell us all about yourself. We had a little conversation prior to us starting recording, and I think you're all ready to tell us more about yourself. So some of the goals of today's episodes to perhaps understand a little bit around the nuts and bolts of the legal system in the UK and where occupational health law and perhaps employment tribunals sit in the system. We are hopeful to build a sort of reasonably broad understanding of occupational health law as it pertains to occupational health physiotherapy, with some understanding in consent, confidentiality, the importance of notes, clinical notes, and understanding optimal report writing and legal matters around that. And maybe also, if we get the chance to do so, to talk about some practical legal advice, if we get the chance to do so, to help physiotherapists that work in occupational health to remain safe and effective at their job. And I think if we do that, I think that would be wonderful. So, Diana, thank you so much for being around with us today, and thanks for having me in your house. I think to get us started, it would be good for our listeners and viewers to get to know you a little bit better. So maybe you could tell us a little bit about yourself and your journey so far up to this point in your life.
Okay, well, it's a long journey because I am old. Well, I was born and brought up in Essex. I went to the University of London, to King's College, and I got a first-class degree in law, and then I got a Fulbright scholarship. So I went to the University of Tulane in New Orleans in America. The reason I went there was because we had a visiting professor from Tulane at King's that year, and he and I got quite friendly, and so I went to Tulane. And that was very interesting because the law of Louisiana is slightly different from all the other states because, of course, it was originally owned by France and Spain. Anyway, so then I got that degree. But when I was there, a professor from Manchester was visiting. I'd never been to Manchester. I was very much south of England. But he offered me a job. And I didn't know what I wanted to do, so I said, okay. So I then went to the University of Manchester as an assistant lecturer in law in 1960. That's 65 years ago. I would always like teaching. And so I enjoyed that. And then I met my husband, who was German. He'd come to lecture in the university. And so we got married. And then we had 2 children, 2 sons. Now, in those days, it was expected that if you lectured in the university and you were female, that you would give up when you had a child. And I didn't want to give up, so I didn't. So I was the first woman in the university to continue after having a child, and I'm in the history book. Now when women, I think they're still fighting for equality, but you've no idea what it was like in the 1960s. Of course, long before the Sex Discrimination Act and the Equal Pay Act. So I got married, I had children. I was lecturing in employment law in the university, and the professor of occupational medicine, who worked in the medical school, I knew socially, not very well. But he said, would I go to the medical school and give 3 lectures on law to the MSc students? They were doing an MSc in occupational medicine. So I said, oh, all right then. So I went and I gave 3 lectures. And of course, I became aware of how much law there was in that field and that there was absolutely nothing written about it. And so then I wrote the first edition of the book, which was published in 1989. and is now in its sixth edition.
Fantastic.
Anyway, so that's how I got into occupation. People ask me, how did you get into occupational health? Well, very sadly, a year after this first edition was published, my husband was diagnosed with lung cancer, although he'd never smoked, and he died 3 months later in January 1990, age 50. He was just 56, just had his 56th birthday. So there I was 50. The children, my eldest son had already graduated and was on an oil rig in the middle of the North Sea. And my younger son was at university. And so what was I going to do? So I decided that fairly late in the day, I would qualify as a barrister. I had done all the exams, but I'd never, to be a barrister, you've got to do pupillage and you've got to be in chambers. So I thought, I'll be a barrister. And so I managed to persuade a former student of mine who was head of chambers to accept me, and I did years pupillage. I was the oldest pupil on the Northern Circuit. When I went into court, not only often had I taught the QC on the other side, I'd also taught the judge. And one judge in Salford said to me, "Don't you lecture me, Mrs. Kloss. We're not in the university now, you know." And he was wrong because he appealed and he was overruled. So I was right. And then I had a place in chambers. But, of course, by then I was getting on for mid-50s.
What's chambers?
Chambers, barristers, aren't allowed to work for anybody else. They're not allowed to be employed. Well, some of them are. Sorry, that's a mistake. But if you're a practicing barrister, and you're not actually working within a company, you're working as a self-employed practitioner. You can't incorporate. You can't have a company. So what barristers do is they gather together, and this is since the Middle Ages, into chambers, so rooms. And so you hire some rooms, chambers, and then you hire clerks. And what happens is, if a solicitor needs a barrister, they ring up the clerk, and the clerk says, "Oh, yes, well, Mrs. Kloss is good in that area, and she could do it for you." And so then I meet the solicitor, and I go into court and do the case. So that's still the way in which most barristers operate. They're self-employed. They don't incorporate. They're in chambers. They get their cases through the solicitor ringing up the clerk. So I did a bit. I did some cases, but of course I was an employment law specialist, and so most of my cases were in an employment tribunal. I did one or two personal injury cases. I did one case about a baby who was born in St Mary's Hospital, Manchester, brain damage, because allegedly the midwife had been negligent and not called for the doctor soon enough when she realised that the baby was struggling. So I did one or two cases like that. But most of the cases I did were employment tribunal cases. And obviously I'd made a good impression because I was then asked whether I would like to be a judge in the employment tribunal. And I said yes. So I was a judge in the employment tribunal after that for 17 years until I was forced to retire because of statutory retirement age. And I very much enjoyed that. And that was, all human life is there. I didn't do it full time. I continued at the university, so I continued with teaching. I continued with, by then the university had set up a separate department in occupational and environmental medicine. And I've been lecturing for them, I suppose, getting on for 30 years, certainly 20 years. So I did a lot. In my life, I've done a lot of things. Then, of course, before that, because of my knowledge of this kind of area of law, I was asked to sit on some government committees. And so I sat for 13 years on the committee that deals with healthcare professionals with blood-borne viruses. And of course, at that time, we'd just become aware of AIDS, HIV and AIDS, and we didn't have the drugs. In fact, I remember one meeting. We used to have meetings in the Department of Health, which was opposite the Cenotaph in London. And the medical director said, "This is top secret, but the results of the research are that these drugs work. I don't think they cure HIV, but they do contain it, control it."
When was this?
Oh, well, it would be in probably the 80s, wouldn't it? Late 80s. And I thought, if I say, "Oh, I'm very sorry, I've got to go get a train," I could go out and I could buy shares in those drug companies and I could make a fortune, because they were only going to announce that these drugs work the following day. And I thought, no, I am not going to do that, because I have too much integrity. So sometimes I think, I could have been a millionaire, couldn't I? Anyway, so I was on that committee, and then we had what was the disease you got from cows eating burgers?
The cow's disease?
Yeah, mad cow disease. I can't remember what it was called now. Well, when that came to light, there was a special committee set up to deal with that, and I was on that. And so I became sort of involved in public affairs in that way. And so eventually I got the MBE for doing that. So that's what I got my MBE for, helping with those public committees.
Did you get to meet the Queen this way?
No, it was the then Prince Charles.
Very well.
Yes. And it was funny because, they announce, you go up and they announce for services to occupational health. And he clearly thought I was a doctor. And so, have to curtsy and all that. And he said, where are you in practice? Where are you in practice? And I said, well, I thought I'd better tell him, I'm not actually a doctor. I'm a lawyer. And I help them because I advise them on legal rights and legislation. He said, "Oh, there's an awful lot of that." So I perhaps made a bit of impression, because he was, in those days, Prince Charles was complaining about all this legislation, wasn't it? Anyway, so you have about 2 minutes, and then you have to walk backwards, and then you have to curtsy, and then you have to go out. But it was a wonderful day, and I was able to take the family, and they were proud of me, and that was very nice. Really enjoyed that. We went to lunch at the Ritz after. Fantastic. And so that was a lovely day. Okay, so where am I now? Well, I'm in the tribunal, etc., etc. Well, then I was asked by the Faculty of Occupational Medicine to be on the Faculty Ethics Committee. So I've been on the Faculty Ethics Committee 25 years, something like that. And of course, we regularly revise the ethics guidance. The current ethics guidance is 2018, and we are in the process of doing the new edition. And we're hoping for the first time, we're going to put it online. Up to now, it's just been printed, but we want it to be more accessible, so it's going to go online.
When you say the ethics guidelines,
yes.
What do you mean by that?
Well, you're a physiotherapist and you are regulated by the HCPC, I assume. And of course, the HPC tells you what you should and shouldn't do as an ethical physiotherapist. It tells you you've got to keep confidence.
Yes.
It tells you, you've got to take care, all those things. Presumably, I mean, the GMC has the most comprehensive guidance. The NMC, the nurses, has fairly brief guidance. I'm sorry, I don't know about the HCP guidance, but you would know about it. But it's not just your legal duties, it's your duties as a practitioner. And as you know, if you did something, and you said to me before, if you did something which brought the profession into disrepute, you could be taken before a disciplinary committee and you could be struck off the register, which would mean you couldn't practice as a physiotherapist anymore, which is very serious punishment, isn't it?
Very.
I find the nurses are more frightened of the Nursing and Midwifery Council than they are of the courts, because they're terrified of being struck off. We're looking at the ethics guidance as we speak, and there's going to be a meeting at the Royal Society of Medicine in November. If anybody's interested, it's all on the website to talk about ethics. And the guidance now isn't just for doctors, although it comes from the faculty. It's not just for doctors, it's for all practitioners in occupational health, which very much these days includes physios and OTs.
Right.
It's not just doctors and nurses. Physio, we now have a multidisciplinary team.
When will this, the recommendations and
the new guidance? Well, I think probably the meeting is in November. I think it is hoped that it will be out in the new year.
Yeah.
Although don't quote me because I can't commit anybody, but that's the plan.
Great.
So at the moment we're having meetings and discussing it, etc., etc. The other thing that happened then was Waddell and Burton. They published some research which was hugely influential, that work is good for you. Because up till now, the general population's attitude was that if you were ill, you were unfit to work, full stop. And that if you were unfit to work, you stayed off work, you got signed off until you were better. And of course, the healthcare professionals were saying the longer you stay off work, the less likely are you to come back. You know, there's a lot of evidence of that. The more you've stayed off work sick, the less likely you are ever to return to work. So you're going to end up on benefits, which is not good for you and not good for the country. And so this research showed that you didn't have to be 100% fit to be at work. You know, if you had, like me, you had a bad back, if there were adjustments made, you had a special chair, for example, and you weren't required to do things which could damage your back, and you had a parking space right next to the office, you could still be at work. You didn't have to be at home watching daytime television. And this really, I think there's still a lot of people in the population who don't really understand that. And so this research actually showed the value of getting people back to work. They also showed that work is a clinical outcome. And this is still not really gone to the medical schools. And I said, you've got patients, if they're of working age, yes, you have to assess whether they can walk and talk and see and hear, yes. But you also have to ask, are they fit to get back to work? Because in most people's lives, that's absolutely central to their welfare. So work is a clinical outcome. We've been trying to push this for a long time.
It's fantastic.
Anyway, so then Dame Carol Black, who no doubt you've heard of, she was appointed by the government to produce advice to everybody about getting people back to work. And so she produced a very, very important report, which said all these things I'm saying. And one of the things she recommended was, she said, I think that all the professions involved in the provision of occupational health services, so that's doctors, nurses, physios, OTs, technicians, they should all be together in a council which represents the multidisciplinary workforce. And so it was decided to set up a council for work and health. Now, this wasn't a government council. It wasn't set up by the faculty. It was just set up generally by people in the profession, people like Dr. Steve Borman, who has been very influential in persuading government that occupational health is important and of value. So they set up a council for work and health. And they said, what we need is we need a chair who isn't a doctor or a nurse or a physio, somebody from outside, but who knows a bit about occupational health. So they chose me. And I, therefore, was the first chair of the Council for Work and Health.
I did not know that.
Oh, yes. And in those days, I think perhaps we had 25 members. One of the members was ACPOHE. And that's how I first became aware of ACPOHE. I didn't know anything about them before that. And in fact, I gave 1 or 2 training courses for them. I gave a course in Glasgow, I remember one. We had no money at all because we hadn't been set up by the government or anybody. So in order to have meetings, and of course this is pre-COVID, we had meetings in person. We couldn't afford to hire a hotel or anything. So we had to rely on our members to provide us with premises. And I have to say the best members were the physiotherapists. They were very generous with giving us their meeting room and with giving us teas and coffees, all those things. They were very, very helpful.
They're quite an enthusiastic bunch as well,
Yes.
aren't they?
Well, they were very supportive of the idea.
Yeah.
I think probably, and the OTs were very helpful too. I didn't really know much about OTs before that, but I became aware of how important they were and what valuable work they do. So they were very helpful. I think probably because everybody before had thought of occupational health as being doctors, perhaps with a few nurses. Nobody thought of it as physios and OTs. So we had meetings, and we published Dr. John Harrison, who's now the head of health and wellbeing for all the police forces. He was a professor in Brunel. He chaired a committee which looked into the provision of a multidisciplinary occupational health workforce. You know, how many people you needed, what sort of backup you needed. And this is in the sort of 2013, 14, 15, those sort of years. That was very influential. That was all new in those days. You know, the idea that you had all these professions working together was new in those days. So those reports were quite influential. We had a secretary who was excellent and is still there, Anna McNeil. She was magnificent. But we had to pay her, of course. And where did we get the money from? So I had to go around with a begging bowl asking people like the physios and the OTs and the faculty to give me a subscription so I could pay Anna. Now, I then, after 7 years, I resigned. I mean, I don't think it's a good idea for somebody to stay in a job like that for very long. So then Steve Borman took over, and he's, steered it. It's gone from strength to strength. So now I think it's got a membership of over 50. Of course, since the pandemic, they're able to have meetings online, which is a big improvement, much easier for people.
Quite.
And, of course, he was already well known with the government, so he has been able to persuade government insofar as it is possible that occupational health is important. You know, he'd already dealt with the health of the NHS workforce, and he was very influential in telling the government, if you're going to spend all this money on the NHS, you've got to look after your workforce. And so occupational health is vital. He'd already done that. So he's been working his socks off to try and persuade governments that it's not just NHS, everybody needs a provision of some form of occupational health. But of course, the situation of the country being what it is economically, there's a recent report, isn't there? But it hasn't gone as far as we would like, but at least it's moving. So after that, John Ballard from the At Work Partnership asked me to do some training courses. They have a business, they put on training courses. And they also published this journal, which is published
at Work.
Which is published, I think it's 6 times a year. And I write a regular column in this.
May I borrow that for a second?
I mean, this one, for example, which is April, May this year, I've written a column on a case in which a woman with a long periods of sickness absence was eventually dismissed by the employer and NHS Trust, but because they didn't follow a fair procedure, they had their own procedure for dealing with a disability. The problem was that they had 3 occupational health reports. I think, or was it 4? No, I think 3. They had 2 occupational health reports that said that this woman, she was a cleaner, was likely to be disabled under the Equality Act. So that meant that they should be using their disability procedure. They had 1 OH report that said, no, she wasn't disabled under the Equality Act. The HR manager decided to follow the last one. Very stupid, because what he should have done is he should have got a completely fresh report.
Quite.
And he didn't follow the disability procedure because he said she's not disabled. And anyway, she sued. In fact, she was a litigant in person. She didn't have a lawyer. She went to the tribunal.
Was she successful?
And she was successful, yes, because the tribunal said, okay, she had a lot of days off work, true, but on the other hand, it was quite clear that she had quite a serious mental health problem. She was disabled under the Equality Act. That was reasonably clear.
Yes.
You should have known that, not just from occupational health reports, but also all the fit notes you kept getting from the GP. And so you should have gone through your proper procedure. And at the end, in fact, attendance had been improving. Also, she'd actually asked for an adjustment, which in the tribunal, the manager said, well, yes, I suppose it was reasonable, but they had turned her down. So she was disabled. They'd failed to follow a fair procedure. They'd failed to make a reasonable adjustment. They admitted it was reasonable. Therefore, they were held liable. And she was given nearly £40,000 pounds in compensation.
Can I ask you about that? So one of the questions that comes up in conversation with our members of ACPOHE is, what is considered
as reasonable? So we write reports and we will, with the employee's consent, and that's another area we probably want to talk about. And we'll write our report, we'll get the consent from the employee to share the report with the employer and employee. And then in our report, we'll detail these are the adjustments that this employee will benefit from having at work and following at work, so that they can stay at work in a healthy and a safe way. Mm-hmm. However, the question is whether or not this advice is reasonable or not. What are your thoughts around
Would you
that?
like me then to move on to the whole question of disability? Because this is a whole new area, isn't it?
It might be.
I mean...
It was just on the off chance.
I think it's important for you to... this is something I consistently asked when I'm lecturing.
Yes.
Well, you must know the definition of disability in the Equality Act. And you must be absolutely clear about what it is. The definition of disability is a physical or a mental impairment, and that does not mean diagnosis. You can be impaired. There's a lot of recent cases on neurodiversity. You can be impaired. Well, you can be impaired, with not being able to walk and so on. You don't necessarily have a diagnosis. Often you do, but you don't have to have a diagnosis. It can just be that you can't walk very well. In the neurodiverse area, they often don't have a diagnosis because there's a big queue of people to diagnose it. So it's not diagnosis, it's an impairment, and you'll be looking at a physical impairment, won't you? So secondly, it's either has to already have lasted for 12 months, or it's likely to last for 12 months. Now, I've had 2 operations on my spine. The surgeon says he can't do anything else. So even if the operation was last week, I would be disabled, wouldn't I? Because it's quite clear that it is likely to last for 12 months. So that's the second thing, 12 months. And then the third thing is it has to have a substantial, which means more than trivial, adverse effect on normal day-to-day activities. What effect does it have on this person? Can they get out of bed? Can they get washed and dressed? Can they cook themselves simple breakfast? Can they get to the bus stop? Can they get on the bus? Can they get to work when they're at work? Can they use a computer? Can they talk to their colleagues? Can they go to meetings? All those normal day-to-day things. And if the evidence is that they do struggle with those things, or some of them, then they are disabled under the Act. Now, if you have multiple sclerosis, HIV infection, or cancer, or if you have very serious sight loss, not quite blindness, but getting on that way, then you are automatically disabled. So you don't have to go through all that. If you're disabled under the Equality Act, then the employer has various duties. The first is not to discriminate against you because you have a disability. So if for example, you're attendance is very poor or your performance is very poor because of your disability, then the employer is entitled, eventually anyway, to say, sorry, I need somebody who can actually do this job, and you can't do it, can you? So they can dismiss you. The problem with this cleaner case was that they didn't do that. So if the employer, Section 15, the employer treats you unfavorably for something arising from your disability, which could be your sickness, absence, your performance, they are entitled to do that. But it has to be shown, one, that they either knew or ought to know that you had a disability, which will either be because you've told them or flagged it up or just from their behaviour. And also that when they dismissed you, that was a proportional means of satisfying a proper aim. So I've got a hospital to run. You're never here. We've tried our best. You're still never here. When you are here, your performance is bad. We can't go on like this any longer. So I'm going to have to dismiss you. That's a proportionate means of satisfying a legitimate aim. I'm running a hospital. I've tried my best. You don't fit in, so I'm entitled to dismiss. Now, that's what this NHS Trust should have done if they thought that, her performance was poor. The problem was they didn't have the proper evidence. They didn't seek up-to-date evidence. And also they didn't follow a fair procedure. Going back to the Equality Act, when you are deciding whether you're going to say to the employer, this person is likely to have a disability, first of all, you can never say definitely that they have a disability or that they don't, because you're not a lawyer. Even a lawyer, at the end of the day, only the tribunal can say whether somebody's definitely disabled. So all you can say is likely, very likely, unlikely, very unlikely. You should never say definitely. There's a case on that called Gallup and the Newport City Council. This is all in the book. Also, I've recently been posting these cases on LinkedIn, and various people have come back to me, said how helpful this has been. So you look at the person and you say, this person is likely to be disabled. You then say, well, she's got a bad back, but she manages to stagger around. She manages to give her lectures, but she should be provided with a special chair. She should be allowed to, say, work on the ground floor so she doesn't have to climb stairs, etc., etc. I am recommending that if you want Diana to continue with this job, it would be a good idea if you made these adjustments. However, you should say it's for you, it's for the business to assess whether you can fit that into the business. And that would raise two issues for the manager. First of all, how much would it cost?
Quite.
How much would this chair cost? Which I would have thought with a large organisation, it would be difficult to argue that you can't afford a chair. But anyway. Secondly, is it practical? Is it going to work? Is it going to actually bring her back to work? If it does, is there going to be a problem with other employees? Is she going to be working in a team? I had a friend who had multiple sclerosis. She worked in the university, and her office where other people who were doing the job she did worked was on the top of the old building in Manchester, which dates from 1870 something. And she couldn't climb stairs. And they couldn't put a lift in because it was grade 1 listed and all that. So what they did was they provided her with a room on the ground floor, but it didn't work because she wasn't with her colleagues, and she was having to speak to them on the phone all the time, so it didn't work well. So that kind of thing, the employer can say, well, yes, we will do our best for you, but because this office is in the old building and there's nowhere else we can move it to practically, because it has to be next to the Vice-Chancellor's office, which is also in the old building. Therefore, all we can do really is to give you a room on the ground floor, and, we'll do that for a trial period. But if that doesn't work, sorry, we're going to, in the university, let you take early retirement or persuade you to take early retirement. So It's not for you to say what's reasonable. It's for the employer to say what's reasonable. I understand there are employers now demanding that occupational health, when they recommend an adjustment, actually say whether it's reasonable or not. But that's ridiculous, because occupational health doesn't know whether the manager can fit that in with the rest of the team, with the premises and so on. It's for the employer to decide whether it's reasonable. And of course, therefore, for the employer to defend it. They say it's unreasonable and they don't do it. And then they're taken to an employment tribunal, as happened in this case.
Yes. I think on that note, from a physiotherapy perspective, we can always try our very best to give advice that we think is within a reasonable remit, rather than advice on significant, beautiful cars to help with mobility and so forth.
It is not a good idea. You won't get many contracts if you start recommending things that are going to cost an absolute fortune. Although I was talking to somebody lawyer saying, well, if it's necessary to spend an absolute fortune, then you should recommend that. I say, yes, well, that I would have thought very exceptional, because employers are going to automatically say it's too much, can't afford it. Reasonable. I think that you lack confidence. You're the experts. All I'm telling you is the law. But you're the experts. You should be able to assess what would help this person. That's where your expertise lies, doesn't it?
Absolutely.
And therefore, if you think that this person is not going to be able to come back to work without the chair or the office or whatever, then you recommend it. But you have to say, however, it's for the business, the management to decide whether it's reasonable or not me.
I think it's a very useful line for our members to be aware of. Now, whilst we're on this subject, in terms of report writing, because we often will give these recommendations in our report, then it brings us on to another quite popular subject, which is consent, and informed consent, the importance of it. First of all, let's talk about consent. What is it in terms of occupational health law?
Well, can I make a very important point, which I still find lawyers don't understand? They come back to me all the time with GDPR. It is now, in fact, not just GDPR, it's UK GDPR, because it was originally an EU regulation. It's now been assimilated into our law, and it is now a UK statute, so it's UK GDPR. What does UK GDPR demand? Well, first of all, it demands that you have a lawful basis for your processing of personal data. So that's one thing. And you have to have, if you're processing health data, a lawful basis under Article 6, which applies to everybody, and Article 9, which only applies to people processing what we used to call sensitive data, we now call special category data. I recommend that you use, I think it's Article 6(1)(b), which is performance of a contract, or if you're in the public sector, 6(1)(e), or if you're in the private sector, legitimate interest, 6(1)(f). I mean, I've written about this, and you could look that up. When that's not enough. You've then got to have a lawful basis under Article 9. And of course, Article 9 contains a specific lawful basis for you, which is Article 9(2)(h), that you are processing data in the performance of occupational and environmental medicine, assessments of fitness to work, and medical treatment. So that's for you, and you use that. You can only use that if you fall within Article 9(3), which is that you are a professional with a professional duty of confidence, either a legal or an ethical duty. And you as a physiotherapist have both. You have both a legal duty of confidentiality and a professional duty under the HCPC rules. Okay. Now that's a lawful basis, and that's one thing. The second thing is that the first data protection principle, which is laid down originally by the GDPR, now the Data Protection Act, is that you must act lawfully. That's different from having a lawful basis, and the lawyers get it mixed up. Acting lawfully means you comply with the GDPR, you comply with the Data Protection Act, but it also means you comply with the common law. And your duty of confidence is a common law duty. Common law, there isn't a statute. Common law is created by judges as they decide cases, and they've been doing that since the 13th century. So it's a common law duty that you have. And the fact it's not in a statute doesn't mean it's not important. It's just as important as the statute. So you do have a legal and ethical duty of confidence imposed by the common law. Now, if you look at lawful bases under Article 6 and Article 9, consent, as defined in the GDPR, is one potential lawful basis under Article 6. One of 6 lawful bases under Article 6, and one of 10 lawful bases under Article 9, but don't use it. You don't need to use it. So for your lawful basis, you don't use consent, right? This is not, fantastic, she's saying something nobody's ever seen. The Information Commissioner in his guidance says this. So I think there's no excuse for these lawyers not understanding it. So, right, you have a lawful basis, you have, say, Article 6.1b and Article 9.2h. Fine, you've done that. And you have to have a privacy notice, and you have to tell people. Now, the next thing you've got to look at is, are you acting lawfully? So, for example, you wouldn't breach the law of libel, would you? Because if you said something in your report which was libelous, you could be sued.
Quite.
Defamation. You wouldn't breach copyright. Because if you used information which it was copyright material and the person who owned the copyright found that, then you could be sued for breach of copyright. If you've hacked into a computer, you could be liable to a criminal offence under the Computer Misuse Act. The Human Rights Act, 1998, brings the European Convention of Human Rights into our law, and that says in Article 8 that everybody has a human right to privacy, which means confidentiality. So there's a lot of law in addition to the GDPR. And so the fact that you are not using consent as a lawful basis does not mean you don't need consent. You do need consent. You need consent to report because you are bound by your common law and ethical duty. And that's recognised in Article 9.3. Okay, so what do you mean by consent? Well, to start off with, at common law, consent doesn't have to be in writing, technically. Actually, it doesn't have to be in writing under the GDPR, for that matter. It can be completely oral. But you would be stupid if you didn't try to get at least some written evidence and put it. Now, the problem now is when you're doing a lot of your consultations on the phone or on Zoom, how are you going to get written consent? Well, my advice is that you ask the person, do you consent? And then you make a note in your records at the time. I made a note. That's writing. That's writing. The other thing you can do is you can ask them to email you. And email is writing. The fact there's no wet signatures doesn't matter. Email is written. So will you please email me to say you've consented? That's evidence. The point about the writing is that this is evidence that they actually did consent.
So if I was to write in my notes that Mrs. or Mr. So-and-so...
I asked her I told her blah, blah, blah. She asked her whether she consented, and she said yes.
Yeah.
That's evidence that she consented.
Very well.
So if she then challenges it later, you can put... The point of being that it's contemporaneous, and of course, when you're doing it all on computer now, you can say exactly when you made it, can't you?
Quite, yeah.
So, if you've, people, if anything goes wrong in a hospital, it's amazing how notes go missing. Or suddenly, that's how they call Shipman, wasn't it? Who murdered his patients.
Is that how they caught him?
Yes, because what he was doing was he killed the person. Some of them he killed in the surgery. And then he would change the their records after it killed them. And so he thought, he didn't know that you could actually check when that happened. And of course, they brought in some super duper IT person who said, I can prove when you did that. And that was after that woman was dead.
Blimey.
And apparently, when he was confronted with that, if you read the history of this, when he was confronted with that, he collapsed on the floor because he realized he wasn't going to get away with it.
He was caught.
Yeah. So, yeah, that's the way. Anyway, where was I? Oh, yes. Now, when you talk about informed consent, the issue at the moment, and it's being discussed in the Ethics Committee, the Faculty Ethics Committee, is what information must the person have before you ask them to consent? In an occupational health, there are two possibilities. GMC guidance, which dates from 2009, says that you should get the person's consent when you see them or when you interview them, to interview them, and to write a report. You should then say, do you want a written copy of this report before I send it to the manager? Because there should be no surprises. If the employee says, yes, I would like a written copy, please, you then say, give me an email address where you're going to be guaranteed to be there in the next few days, weeks. And you say, I'm going to send you an email with the report. You have, many companies say 48 hours. You have 48 hours to consider it. If you don't come back to me within that 48 hours, it will go to the manager. It's what I call the Cinderella rule, you know. If you don't leave the ball by midnight, your coach will turn back into a pumpkin. It's a negative procedure. And that's what the GMC and the faculty have accepted to be a valid way of getting consent up to now. However, I wrote an article, an editorial on this in Occupational Medicine recently. There are a group of doctors, mainly I think from the NHS, who are saying that's not good enough. What we do is we say to them, do you want a written copy? Yes. We send it to them. We say you've got 48 hours, 5 days, whatever. If you don't come back to me within that period, it won't go to the manager. So you're asking them to give, as it were, a second affirmation, a second consent, when they've actually read it. And because they say, and I can see the argument, how on earth can they genuinely consent to something until they know what's in it? And I think that's a reasonable argument. However, there are some of the big occupational health provider companies who want to keep the negative procedure for at least some cases. And so we're arguing about this. The GMC has produced new guidance on consent to operations.
Can I just come back one step?
Yeah.
So this slight link here between the sensitivity and the level of consent in terms of releasing reports. So we have the case study or the example that you're using, that the employee would like to see the report. We send it to them, and we give either a positive or a negative incentive to read the report, that if they do or don't read the report, then the following will happen. Now, let's say if someone, one way or the other, they withdraw consent at that point.
They come back to you and say, no, I don't like it.
Quite. Yeah. Can we then, we couldn't then release the report.
No.
Secondly, if they said, well, we're happy for you to release the report if you change aspects of the report in terms of
which they often do,
these findings, what is our obligation insofar as following?
Well, you are professionals. So if they come back to you and say, your report's wrong, you say, I'm 25 and in fact I'm 35. Or you say, I'm married with 6 children and in fact I'm gay and I haven't got any children. So you must check. Now that's a mistake of fact, isn't it? And a doctor I work with very regularly who comes from South Wales, and is called Williams, says that it is not unheard of in South Wales for occupational health reports to refer to the wrong employee, because there are so many Williamses and Joneses in the factory that sometimes they get mixed up.
Quite.
So clearly you're going to change that, I hope. However, if it's an issue of your opinion, your professional opinion, you will not change that just because they don't like it. You might say, well, okay, I see your point, so I will add to it. I will say, however, some people think, it's for you as a professional to decide what you as a professional with integrity.
We could also add a line from the employee that the employee might disagree with aspects of this opinion.
Yes, you can say to them, well, I'll add a paragraph that says, although this is my professional opinion, however, the employee contests this, and the employee's opinion is that you can do that. If you want to do that, if you agree to do that, it's up to you. But don't change your professional opinion just because the worker doesn't like it. And also just because the employer doesn't like it, because you're going to get pressure on the other side as well.
Quite. And then, then the other little detail is the point where, let's say the employee withdraw consent. We do not want you to say anything further to employer, withdraw all consent, no reporting, and no more contact between you as an occupational health professional, physiotherapist in this instant, and employer. However, employer has referred this employee for the assessment. Can we at this point, Diana, or do we still have to at this point, inform employer, the referrer, that the employee indeed has withdrawn consent?
Well, if you don't, they're going to come back and ask you, aren't they? At some stage, you're going to have to say, I have written a report. However, the employee has withdrawn consent. Therefore, I cannot give it to you. There are, of course, exceptions. There are always exceptions. And if that employee, in your professional opinion, is unsafe, so that if they go back into the workplace, say driving or operating machinery, they are going to be a hazard, then you're entitled to report without consent.
Is that right?
Oh, yes, definitely. And all the professions will tell you that. Do you know the case of the Glasgow bin lorry driver?
No. Oh, was that the terrible accident?
Yes, it's about 10 years ago now, I think. Yes, this was a man, I think complete villain, actually. He knew that he had some condition which, I don't think it was sleep apnea, but it could have been, something like that. He from time to time fell asleep.
Narcolepsy, perhaps.
Something like that, without warning. So what does he do? He applies for a job with Glasgow City Council, driving a bin lorry. A great big enormous bin lorry. He doesn't tell, well, I don't know. The occupational health people say we didn't know, but I was talking to a physician recently and he said, well, they did, The point was that this man was never prosecuted, so it never came out in court. But there was a public inquiry. And I'm told that the occupational physician was really put through the mill by cross-examination in the inquiry. So anyway, so as far as I'm aware, occupational health didn't know. He didn't tell them. So he's driving this bin lorry in the middle of Glasgow in the Christmas rush, and he falls asleep at the wheel, and the bin lorry mounts the pavement and kills 6 people and injures several others. The man is not prosecuted. I think he should have been. The Procurator Fiscal decides in Scotland, But there was this public inquiry, and you can look it all up on the internet if you want all the details. Anyway, after that, both the GMC and the NMC, I don't know about the HCPC, but both the GMC and the NMC sent out information to all their registrants. If you become aware that somebody is unfit to drive, they are a hazard, you should tell DVLA. Not just you can, you should.
You must.
Because they didn't say must. Because of course, people would say sometimes, well, you tell me, people tell me, they go to the window, they see this, you mustn't drive. Oh yes, I understand. So you You get to the window, look out, and there they are walking to their car, driving off. Yes. So you may think, well, I'll give them a week. And people tell me, well, they give them a week. Then they check whether they've got in touch with DVLA. But maybe in that week, they could kill 6 people. So I'm not sure that. But I can see the problem. I mean, you will understand this. People are frightened that if they do report without consent, then they're going to be dragged before the GMC or ACPOHE.
And they might lose their accreditation for breach of consent.
Yes, but, I mean, you wouldn't do that lightly.
No.
I mean, what the advice is, if you think somebody is unfit, I think really you have a moral duty, don't you?
Mm.
But what you do is, the first thing you do is you consult with a fellow professional in confidence. If you're in the NHS, it could be a Caldecott guardian. It might be the head of your department or whatever. Somebody you trust, somebody who's senior. And you say, I've got this case and I'm really worried. This is the evidence. If you then decide that you've got evidence that means that person is unsafe, you then say to that person, I am going to, if you don't report yourself, I'm going to have to report you. And then what some people do is say, I'll give you a week. Both the GMC and I think generally people think you should give the person the chance of reporting themselves. But there could be a situation, couldn't there, where he's so dangerous that you wouldn't give him that chance. You know, you'd say, I've got to report now.
Quite.
Depending on what the condition is. Then you have to check, because a lot of them say, well, I have reported myself, and they haven't. This is difficult because, of course, DVLA has to get consent. But what I was at a meeting when the head doctor at the DVLA said, well, the thing to do is you say to them, if you actually did report yourself, you will have paperwork which the DVLA will have sent you. So I want to see that paperwork. If they can't produce it, that means they haven't reported it. So you then report it. But public interest is a well-established defence to reporting without consent. The leading case, actually, is about a man who was in a secure mental hospital, Ashworth in Liverpool, because he had killed 5 people at a petrol station in Birmingham by shooting them. He liked bangs, he liked guns. He was paranoid schizophrenic. So he was in this secure, he was convicted of, you can't murder, because murder, you've got to have an intention to kill. And he was so mentally ill, he couldn't do that. But he's convicted of manslaughter. So he's in this special hospital and he wants out. So in order to get out, at least to a less secure hospital, he has to have a report from the medical director. And he's managed to con this medical director that as long as he takes his drugs, he's safe.
Clever man. But
he also needs a report from an expert witness to support it. So his solicitor gets this psychiatrist, Dr. Egdell. I met him actually once. So Dr. Egdell has his consent to examine him and to report to the Mental Health Review Tribunal. And Dr. Egdell interviews him, and all he talks about is how he likes guns and bangs and bombs. And so at the end of it, Dr. Egdell says, this man is seriously unsafe, and writes a report to that effect. Then, of course, it's called W. We don't know the actual name. W says, I do not consent to you sending that to anybody. And Dr. Egdell says, I don't care. And he sends it to the medical director of the hospital and to the Home Office. He says, they need to know you're not safe, and I don't care about no consent. So W sued him for breach of the obligation to get consent, and lost in the Court of Appeal. So we're not just messing around in the employment tribunal. This is a higher court.
Quite. Because
the Court of Appeal said, well, Dr. Egdell might have been wrong. He might have been wrong. You might be safe. But Dr. Egdell had evidence that made him suspect, on the basis of good evidence that you weren't safe. And it was more important that the community was protected against you than that you got out of prison.
Very interesting.
Well, just the sequel to that, eventually he did get out, and he moved back to Birmingham, and he called himself Harry Street, and he was creating hell for his neighbours, and they became suspicious that he was building bombs in his garage. So they reported him to West Midlands Police, who investigated, found out that this was the W, and they raided his house, and they found evidence. He was planning to kill people again. And so he was tried, and he was convicted, and he went back to the mental hospital where he died. So Dr. Egdell was right. It wasn't safe.
I guess in terms of how we could reflect, because that's an extreme case.
Yeah.
I guess in terms of physiotherapy, we do see people which we would consider to be functionally unsafe to return to work. And whilst it's quite rare that we see people who will
going to kill people.
Oh, yeah, quite.
I hope so.
And the other thing that guess is also quite rare, that people would be extremely eager to go back to work, shall we say, in that instance, particularly if there's good systems in place to help them with sick money and so forth.
Yeah.
Maybe a good pension and what have you all. But it does happen. And I guess the cases where we do come across similar instance would be where someone has significant problems with dizziness or their balance and their mobility and their dexterity.
Like me, yeah.
and they might need to operate perhaps as part of their job machinery, not only in the vicinity of, like, let's say, a big vehicle around the vicinity of the public, but even in a factory where there is danger to their physical health and others if they're not able to undertake their job safely.
Yeah.
So could you potentially then say that if we were to come across a case like that, it would sort of suggest then that we have to report that back as a duty?
I don't know. You see, what GMC and NMC didn't say you have to. They said you should. But I think, it's part of your professional integrity, isn't it? And it's not just law, it's morals. That person is unsafe and they're going to kill somebody with a machine rather than, because they murder them.
Yeah.
But you see, I'm sorry, but you are a professional. You've got to assess the risk and you've got to make a decision. And I can't help you with that because I'm not in that position. So you need to consult with somebody from your profession, talk it through and make a decision whether morally, legally, ethically, you have a duty. Because if you don't, and there is an accident, potentially you could be prosecuted.
Yes, quite.
Or sued, potentially. So, but people want me to say, no, definitely not, or yes, definitely, and I can't because I'm only a lawyer. These are, I'm afraid, they are professional decisions, which is part of being a professional. And I'm a lawyer. I have a duty of confidence.
Yes.
So, I have to be careful.
Yes. Very interesting. We do have just a couple of more things that will be interesting to talk about. And these were questions that were raised by people from ACPOHE and our members.
Yeah.
And one of the things we spoke about, that we've been asked about, is pre-employment assessment in terms of physical fitness. Where do we stand in terms of that? So someone will come in, we are part of our job, we will carry out an assessment of their physical capacity. Perhaps they're a police officer or a fire service operator. I'm not sure what the politically correct name is these days. However,
can't say fireman, can you? Firefighter.
Firefighter. And we need to determine whether or not they're physically fit to undertake their job, do our assessment with them. Was there a legal basis to do that? And B, I guess we already touched on it, but can we then also report back to employer to say, well, actually, they're not fit for work, and if they didn't get the job, would we?
Well, that's what you've been asked to do by the employer.
Yes.
But just as you know, if they're in work and they're not off sick, the employer will ask you if they're fit to come back. It's a similar situation. The only thing is that under the Equality Act, you're not allowed to ask, and the employer's not allowed to ask questions about health, and that includes sickness absence, until after the employer's made a conditional offer of the job. Because if, as it used to be, the employer gets to know that somebody's got a health problem before they even interview them, it's amazing how many of these people didn't fit or didn't do well on the day in the interview because the employer doesn't want to take somebody with a disability. So now, under the Equality Act, they have to make a conditional offer of a job first, and then they have to send people to occupational health to say, are they fit? Now, there are exceptions to that, and one of the important exceptions is that if there's a recruitment procedure where that person's disability might put them at a disadvantage in that procedure. And I mean, a lot of it's coming out now with neurodiversity. You know, this person has dyslexia, and part of the appointment procedure is to produce a document or do a written exam. Or this person has hearing problems, and therefore, unless there's proper hearing provision, they can't hear questions and they're not going to do well. All those sort of things. So occupational health can say to somebody, even before they've had an offer of a job, do you need any adjustment to the recruitment procedure? And they're allowed to ask those questions, and then they can make a recommendation. And that's important because there are plenty of cases in the law reports where people should have got the job, were competent to do the job, but because they couldn't get through that hoop of the exam, they didn't get it. So that's one point. The other main exception is employers are allowed to ask a question about anything which is intrinsic to the job. So if they haven't got that quality, no way can they do it. And the example given in the Code of Practice is a scaffolder somebody who's going to be working on a scaffold but can't climb ladders. So occupational health is able to say, can you climb ladders? Because that's intrinsic function of the job. So there's all that law. There's plenty written about that. I've written about that. Now, if you are asked by the employer to say whether somebody's fit and you decide they definitely aren't, in your professional opinion, then you can report that they're unfit, and you can report without consent if they're dangerous, just as you would be able to do if they were actually in employment. But people don't obviously want to do that. They're unhappy about doing that. There's also data protection issues. There's a recent case of a man called Q who applied for a job, an office job with a company called L. And he revealed, the employer asked their independent occupational health provider to say whether he was fit or not. And Q revealed to the occupational health physician that he had Tourette's, which is a neurodiverse condition. So occupational health wrote a report to management saying that he was fit to do the job. Did not mention the Tourette's. The man got the job. He was doing the job. After a few months, it became obvious that he did need some adjustments because of his Tourette's. So his behaviour gave cause to concern. But at first, the employer refused to make adjustments. The man himself was saying, can I have this, can I have that? And the employer was saying no, because the excuse often is if you get it, everybody else will want it, which is not a reason for not making a reasonable adjustment for somebody who generally has a disability. Anyway, eventually, Q sues L in the employment tribunal. And the question is, the employer says, but we didn't know you had a disability. We didn't know. Because the report from Occupational Health didn't mention it, said nothing about the Tourette's. So we didn't know. And so the tribunal has to decide, did the employer know? Because the employer can't be held liable for discrimination if they didn't know that he had a disability. And they held, no, they didn't, because it wasn't in the OH report. OH had got his consent to send this written report, didn't mention the Tourette's, and that meant the employer didn't know. Occupational Health knew, but they didn't put it in the report. The employer did not know. However, after several months, probably the employer got what we call constructive knowledge. So even though they weren't told in words that he had something wrong, some problem, by his behaviour.
Yes.
So in your sort of context, I mean, if somebody comes in limping all the time, well, like me, staggering around with a stick, and the employer said, I didn't know whether they had any musculoskeletal problems. I was totally unaware of it. Nobody told me. Occupational Health didn't tell me. Well, they didn't need to, because you could see for yourself. And that's constructive knowledge, so that's good enough.
Very well. Very interesting. Fine. So there's a sort of ocean of other questions I have for you.
Yeah.
However, I think we have covered quite a lot of information today. Is there anything else that you would like us to talk about?
I thought when I was looking to see if there's anything on the internet, I found this. This is Physiotherapy, which is a magazine, isn't it? And it's Clinical Negligence and Physiotherapy, UK survey of physiotherapists' experience of litigation. And I think it's under the auspices of Manchester Metropolitan University. My university, where I still work, University of Manchester, which is the old one. The MMU is the more modern one, the more recent one. And this gives quite a lot of information. It says 10% of respondents had been involved in litigation. 128 claims were reported, with some respondents being involved in more than one case. Litigation was a highly stressful experience for those who experienced it and was a source of concern for many others. The personal impact was stress, 76%, and worry and anxiety, 67%. The most common professional impact was defensive practice.
What does that mean?
Well, I think it means that you were so scared of being sued that you didn't put something in that maybe it would have been helpful to put in. I mean, we did discuss that before, didn't we?
Yes, quite.
You're a professional. You've got to give your professional view. The idea that you won't mention something because, oh dear, if I say that, they might object to it. Well, if they object to it, they won't consent to your report, will they?
Quite.
But just as Dr. Egdell, I mean, he's stuck his neck out, didn't he? He said, I don't care. He's dangerous. I don't care. I am a psychiatrist. I'm a doctor registered with the GMC, but this man is not to be allowed out. He's dangerous. So, I mean, to an extent, sometimes you have to do that. This is interesting. Most, 77%, reported that litigation training should be included in pre-registration as well as postgraduate programs. So I think that's interesting, and maybe that brings us back to our discussion.
Quite. So training in
litigation. Legal liability. You don't need to know all of it, obviously, but you do need to know do you call them red flags?
One of the most important courses I ever went to was in the beginning of my career in the NHS in Grimsby, in Cleethorpes. And it was called Solomon's Notes on Trial, I believe. And it was a barrister, Mr. Solomon, I believe, who took us through a practical course on the importance of note-keeping.
Note-keeping, yes.
And back then it was handwritten, which held its own type of, risk and danger.
Yes.
However, very interesting course, and where some of the things that we have spoken about today, I recall him talking about it back then. But also in addition to that, what he did do, he took us through, every single one of the attendees it took us through a mock trial where
Oh,
we would actually be in the, what do you call it now?
well, this would be you were being sued for negligence.
Quite.
So that would be in the High Court or the County Court.
And
Yeah.
you'll be in a box, you'll be in a
The witness box, yes.
Yeah, and he would essentially take people apart as part of the court.
Cross-examination, yeah.
One or two of the people in the courts actually start crying.
Oh.
But all of us, insofar as like experience of what that felt like, I mean, I can't think of anything better. And it certainly made me very, very aware of the importance of sound note keeping as the base of everything that we do, because that, in the end of the day, everything we do, everything we advise, everything that we communicate.
Yes, always keep a note. Yes, and I think these days it's easier, isn't it, when you're doing it, on a computer?
Yes, it certainly can be.
Although maybe I sometimes think there's too much of these tick boxes, and maybe putting an actual note would be more helpful. But of course, those are clinical negligence cases. My main experience is employment tribunals, which aren't quite as formal as that. But you still have to give evidence, and you can still be cross-examined, yes. But they're not as frightening as the High Court.
Very, very quickly, because I realised I've forgotten to ask you this. We just spoke about notes, and it just triggered my mind. How long do we hang on to clinical notes?
To notes. Well, the dreaded GDPR says you keep them as long as is necessary, which is very unhelpful, isn't it? The NHS Digital, they recommend you keep them as long as the person is actually in the job, plus a minimum of 6 years, or until their 75th birthday, whichever comes first. But that's not the law, that's just what they recommend. I was talking to a big occupational health provider, and he said that our insurance company says that we have to keep them for a minimum of 10 years. Well, that's a good reason for keeping them. It is necessary. You're necessary to have insurance.
Yes.
So 10 years, if that's what they say, you keep them for that. If you have records, you should be going through them every so often and saying, can we discard those? If there's any question that they might be used against you to sue you, or you might want to sue somebody, you're allowed to keep them longer. If you're doing research or you're collecting statistics, then you can keep them indefinitely. However, if you're doing that, if you're keeping them for that reason, you should at least pseudonymize them, which means you separate the actual data from the names to which data relates, or you make them completely anonymous, because none of the data protection law applies to completely anonymized data. But, so that, I advise the University of Manchester, they have a scheme with the HSE whereby they have all these doctors around the country, both GPs and occupational physicians, who say, I saw somebody with a work-related disease, he was 35, and he did this job, and they send this information to the university. Now, the researcher doesn't know who that is, but the doctor does. So you could, in theory, marry up the names with the data. The researcher doesn't, but they could. Yeah. So that's what we call pseudonymized data. It's not completely anonymized. The GDPR does apply. And you should, if you're using it for research, so the researcher can't find out who the person is.
Yes, quite. Very good. And I guess to finish us off, for any worried occupational health physiotherapists out there that might be worried about occupational health law, the law in terms of their own practice and working in occupational health, is there any message that you would give to members of ACPOHE and physiotherapists and occupational health in terms of keeping ourselves and our employees and employer safe and sound bigly?
Well, I think really there's two questions. First of all, how do you do your job? And I can't tell you that. I have to say I do have a physio who comes to my flat every week, and he's wonderful. And I trust him absolutely. And because of me, he's decided to specialise in physiotherapy for older people, because he says that there's an awful lot of people doing sports medicine.
Yes.
But there's not very much, and it's very important that people like me are able to stay in my own home for as long as possible and not block a bed in the NHS. So I think that's extremely valuable. So I can't tell you how to do that because that's your profession. When it comes to the law, clearly you've got to have insurance, liability insurance, and you'd be very foolish if you were in practice and you didn't, because although most of your patients are not going to sue you, there's always potentially going to be one. And as this research shows, something like, was it
10%?
Yeah, 10% did get involved in litigation. So we must have insurance. I think we all make mistakes. Well, none of us perfect. So you will potentially make mistakes. But if you've got integrity and if you follow procedures, and I think it's very important, you're in ACPOHE. They do have regular courses, don't they, and conferences. Go to those, learn from other people. And if you've got a problem, discuss it with other people. I'm very worried at the moment about AI, which I don't really understand, artificial intelligence. But there have been a series of cases now in courts where lawyers have turned up and they've referred to a case, like I've been referring to a case, W against Egdell, and giving a law report. They've got it off AI and it doesn't exist. Because apparently, if you ask AI, have you got any cases about this, and they can't find anything, they'll make up something for you.
Is that right?
And these lawyers have been threatened by judges with contempt of court. You can go to prison for contempt of court because they've been quoting to courts cases that don't exist. They've been made up by artificial intelligence.
That's not good at all.
And where do you get this information from? Where do they get their data from? Are you giving them data which has got names attached? You should never do that. Anonymized data, then fine, yes. But, the whole thing worries me because I suppose it's not my generation, but the idea that there's this person in the sky, who's able to make things up, very convincing things, without being fraudulent, just because they're trying to be helpful. It's quite frightening.
Just on that note, I was listening to, just prior to Women's Hour, driving up to see you, I was listening to people using GPT.
Yes, well, that's AI, isn't it? Chatbot.
Quite. Yeah. For therapy. For, whether perhaps not psychotherapy, certainly for, what is it called? Cognitive behavioral therapy. And actually finding it quite beneficial, however, quite superficial.
Well, be careful.
Quite.
Well, I have to confess, I was doing an article recently, and I knew what I wanted to say, but I got my knickers in a twist setting it down. And so eventually, I'd never done it before, I asked this chatbot. And they didn't change anything, but they did put it in much more accessible format. So I was very grateful for that.
Quite.
So I think it's a useful tool, but I do think we need to be careful. Janet O'Neill, who's, there's a National School of Occupational Health.
Yes.
And she's a nurse, she's the deputy head. She's been doing research into that and she's produced a report, which I think is available on the internet. Because I do think professionals are going to have to be very careful.
Yes. Also in terms of report writing, which a few companies now are starting using AI to actually write the report for them, with the caveat they have to read their own report and make sure it's correct prior to releasing.
You can put the information in, but don't let them make up something else.
No, quite. Diana, thank you so much for having this conversation with me today. And no doubt, following on from this conversation, I'll have a conversation with my people in ACPOHE, and they will say, you haven't asked her this, and you haven't asked her that. So who knows? I guess I wouldn't be surprised to see that in the future. We might contact you again and see whether it would be possible to have another conversation. It's been extremely helpful. Thank you so much for your time today.
Thank you for coming and asking the questions. And I'm sure you're going to have to edit out some of it, but I've tried to cover what I think is relevant to you.
Thank you so much.
son's going to say, Mother, you talk too much.
You talk brilliantly.